This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Mr. Mojumdar, Mr. A for CBI, Mr. Trivedi for ED, Ms. Swanso for the petitioner responded. At the outset, Mr. Mojumdar and Mr. Trivedi contend the appeals are not maintainable against the orders stated against the impugned orders. The orders were passed in a writ petition relating to investigation in offences relating to investigation of investigation into corruption by the then principal and other officials of Archie Court Hospital. In view of Ram Fauji versus Swanso, the appeal against the said orders are not maintainable. It is also contended. Earlier appeals by an earlier appeal against refusal to add Sandeep Ghosh, appellant in MAT 170/2025 and MAT 171/2025 in the proceeding was dismissed by a coordinate bench presided by the Honorable Chief Justice and upheld by the Honorable Apex Court. It is Apex Court. In rebuttal, senior counsels for the appellants contend the earlier appeals pertain to a different aspect of the matter.
Just to assist your lordship, we didn't file any appeal before the division bench. We filed SLP against that order. Before the Honorable Supreme Court, the SLP was dismissed by one line order.
Learned senior advocates contend no appeal was filed against to add Sandeep Ghosh as a party before the honorable division bench. An SLP was filed, special petition was filed, which was dismissed. Be that as it may, it is it is further submitted. The appeals, the present appeals, do not pertain to the right of the investigating, do not pertain to the issue relating to transfer of investigation to CBI, but are directed against, but challenge the direction given by the Honorable single judge, directing the trial judge to conclude to consider framing of charge within 7 days. It is submitted. The said order runs counter. The said order runs counter to the provisions of BNSS. Runs counter to the provisions of BNSS, as well as ratio in the High Court of Allahabad, which bars the constitutional courts to pass directions for disposal of proceedings within time frame. Within a time frame. Full stop. It is within a time frame. Recalling the matter, the earlier appeal, Sandeep Ghosh preferred the earlier appeal against 25.
No.
Suman has tried it.
You did.
Yes.
Well, the last two
How
appeals.
can there be a second appeal against?
I have challenged the
Cannot prefer a second appeal against the 29 one.
Same order.
No, I have also filed another appeal.
That
I've
is
also
what we
filed-
are saying. We will consider your appeal against
Yes,
review,
recalling.
the recalling application after the appeal in
I
respect of the earlier application. That appeal is not maintainable.
We'll address that later.
That appeal is not maintainable.
We'll address
We
that
can
later.
consider that with regard to Sandeep Ghosh or with regard to Dr. Ashish Kumar Pandey.
No, mine is also there. Mine is also 174 is out.
How many of these appellants challenged the first order before the
One.
who was that?
Me.
That appeal is dismissed. You cannot maintain the second appeal against that order.
But that appeal was never heard. What I was saying is, Marat, if the liberty was granted that I should go back and then, yeah, I understand, Marat.
What are you saying, Mr. Banerjee?
Yeah, I think that
At least maintain
I understand.
some
Marat.
degree of
I understand.
respect for the.
I understand, Marat, what you're not saying. I
What do you
understand.
understand? Why are you submitting? Huh? This is your understanding of law. An order is challenged. A coordinate bench refuses to entertain your appeal and asks you to pass a recalling order. Your only remedy is to challenge that order in SLP or to file. You accept that order, and if you accept that order, you cannot come back and challenge the earlier order.
Marat.
The earlier order may be challenged by others. That is another thing. We are not
My second one will survive.
with regard to Sandeep Ghosh or Ashish Pandey. It cannot survive so far as your Suman Hajra is concerned. Institute
Yes.
was on mentioning
Yes.
the coordinate by the Honorable Chief Justice. Observe that, please file recalling appeal.
Yes.
So it is my duty to point out, your lordship, Lord, so far as Fauji's principle is concerned, Lord, one of the accused we filed a quashing application under 226. Who are the petition? Now, Lord, the single judge did not, Lord, pass any interim order. Against that order, Lord, two appeal was filed. One bench presided by Honorable Chief Justice, other one by Malaya Justice Tandon. Now, Lord, their Fauji subsequent judgment, Gopal Agarwal, and our High Court's judgment was discussed. Lord, I appeared for the petitioner, and Mr. Bandopadhyay was appearing for the state. And ultimately, it has been referred to the larger bench. We will love to, if your lordship can preside that bench.
Larger bench thing we will consider, but I have made myself clear.
No, I understand.
Here the direction is to be examined from two angles, not only as a criminal matter, but an issue of natural justice. Whether you can give a direction for consideration of charge without giving opportunity of hearing to all the accused parties.
But subject to your lordship's correction, then the same principle will apply when at the time of the investigation, when CBI took the investigation, where order was passed.
No,
They
sir.
wanted to add it as a
Oh,
part.
no, not at all. Because principles of natural justice do not apply to the investigation. Principles of natural justice apply with all full force when it comes to a post-cognizance proceeding.
Commencement of trial. Your
Post-cognizance proceeding,
lordship.
and here a vital right of consideration of charge is fixed within a time frame without hearing other accused person. One. Secondly, whether this direction could survive a review in light of the ratio of the constitution bench.
Then, my lord, I need to borrow your lordship's own quotation. The statutory provisions are handmaid of justice.
Again, we say, what are High Court of Allahabad is a statutory provision. Judgment in High Court of Allahabad is
Even, my lord, to that extent.
judgment of High Court of
No.
Allahabad is a statutory
No, that
provision.
is not correct.
It's a clear mandate to every constitutional courts.
But today, even in a bail application, Malaya Justice Oka has said, my lord, that no court can direct.
That is exactly what we are saying.
Yes, yes, I understand, my lord. I
We
understand.
are resonating the constitution bench view. If there is a bar on all constitutional courts to give a time frame for disposal of cases, the same applies with regard to stage of criminal proceedings also. And in doing that, you are fixing a burden on the court, and that burden is fixed in violation of law declared by the Supreme
Statutory
Court.
provision and
Is it not amenable under clause 15? Is it a
Yes,
criminal
yes,
matter? One. Number two, again to the first point, this is a post-cognizance direction for a stage of trial without considering a ratio of the Supreme Court, without hearing all the accused person. Is it not an order to the extent of giving the direction for 7 days, order in breach of principles of natural justice and thereby void ab initio? If that is so, will Ram Fauji apply?
we love
So
to
these
address
are
this
issues.
before your lordship. Yes.
They will take some deliberation which you may address. We keep the issue open,
Yes.
but we say that as of now, as an interim arrangement, some pressing requirements
Yes,
are
yes.
there. If this issue goes on arguing, they will be the happiest. They will argue at length for 6 months that Ram Fauji does not apply and everything will get stalled. So let us keep it. In the meantime, you fix the time frames for supply of copy, and by Tuesday, we would expect all copies to be supplied. We will give the next proposal, which again we would request you to give, because we will not give proposal. We will ask the trial judge to fix. The bar is on the constitutional court. The bar is not on the trial judge. He can fix. And we will request the trial judge to hear and fix a time schedule for hearing the
Discharge application.
discharge application and framing of charge, bearing in mind the relevant provisions, and we will keep the oversight of the appeal with us. All
At
right.
your lordship, please.
In fact,
Okay.
Maharaj, I'll
All
tell
right, Mr.
Maharaj, I'll just indicate to your lordship what had happened. When this issue first cropped up, Maharaj, I had appeared before the trial court, and I had indicated that possibly this is just a direction. It's directory in nature, not peremptory in nature of the 7 days. So the trial court says, no, I am bound by it. So I came up for recalling directly without the leave of the Honorable High Court. When the first time I had mentioned before the single judge, he said that I did not mean it. I said consideration of charge. I said don't frame charge. All I wanted was the process to be expedited. And it got misunderstood. When I'm telling you, Lordship, I can't, of course, put this. He said it's been misunderstood in a particular manner. Anyways, you should have. I said I did. I tried. I failed. He said that he's bound by the letters of this Honorable Court. So he said that I can't do anything. You have to go up before the Higher Court. I prefer an appeal. By mentioning the matter, I said that this is the situation. My charge is getting framed. So the division bench said that no, I will. What you do is, since you were never heard, it's your incumbent duty to tell the Honorable Court that this is what has happened. So I said that I tried. Yes, last evening. If you want, I can put an affidavit from the advocate on record. He said, don't record, don't embarrass us. I'm putting this on record. He said that you bring CBI on board, CBI and ED on board. CBI and ED came. Matter was mentioned at 10:30. Then at 12 o'clock, the CBI and ED came, and then that observation was made. That's all. This is what happened. The single judge was
Whatever we are keeping this appeal
Maharaj.
alive,
Maharaj.
and let the copies be supplied. And
But just now I got information the application which Mr. Bhattacharya has filed that has
No, I have not, my friend, my learned friend.
My lord, another accused.
I have not filed my lordship.
that has been released now.
get it aside.
It will be assigned here only.
All that. Get it as a text step.
Yes, we will take steps.
We'll
Tuesday. Deeply.
I'm grateful.
Who is that accused? The one.
One
Biplab Singh.
One
Biplab
Biplab Singh.
Hasra, Biplab Singh. These are medical supplies.
They are the
We've been caught in this.
Milord, without the work order, Milord, the number of tenders has been
I
available to them.
I will not open right now. Let them say what they have to. I'll open at an appropriate
We
stage.
will pass audits.
Yes.
All right. We'll keep it on Tuesday.